Assalamualaikum warahmatullahi wabarakatuh. So today my group will present a case between the Food Industry Employees Union and the Palmaju Edible Oils and Grain Berhad. So before we begin our presentation, I would like to introduce myself and my group members. So I am Nur Afifah binti Azahar.
Hello, my name is Nur Aina binti Usni.
Hi, Assalamualaikum. My name is Muhammad Azal Hafizi bin Muhammad Rizwan.
Okay, moving on to the case summary, which is I will summarize this case. So this case is between the Food Industry Employees Union and the Palmaju Oils and Grain Berhad, which is the Food Industry Employees Union is the trade union party and the Palmaju Edible Oils and Grain Berhad is the respondent. So under Section 56, subsection 1, the trade union had filed a complaint towards the respondent regarding the failure of the respondent to abide with the collective agreement. It is stated that the respondent did not inform the trade union party regarding the changes of working hours, and the trade union also dissatisfied with the calculation made by the employer by the respondents regarding the rate of overtime. Okay, as for the case of the trade union, it's based on the non-compliance of the respondent towards the collective agreement. So this collective agreement had been effective on the 1st January 2011 until 31st December 2013. So the trade union had filed a complaint of the non-compliance of the respondent on the 5th December 2014. So the both parties, which is the trade union and the respondent, had signed an agreement that will be effective on the 1st January 2014 and can be used until 31st December 2016. So it had been mentioned that the collective agreement made on the 26th November 2014. So it means that when the trade union filed this complaint of non-compliance of the respondent, the collective agreement that been effective on the 1st January 2011 until 31st December 2013 is assumed to be ended. So the court need to make an investigation and later make a decision whether to hear this case or not. So after investigation had been made, the court decided to hear this case. So as a conclusion, the court made a decision to reject this case that been filed by the trade union because the respondent had found not to be guilty in this case. Okay, moving on to the case dispute, which is I will explain the facts and issues that can be found in this case. So basically, the trade union party felt dissatisfied and did not agree with the action taken by the respondent, which is the respondent did not inform the trade union party regarding the changes of the working hours. Besides, the trade union party also did not agree with the calculation made by the respondent regarding the rate of overtime. So basically, the trade union party mentioned that the respondent did not abide with the clause 16 and 19, which is clause 16 is regarding the working hours and clause 19 is regarding the rate of overtime. Okay, as for the issues, there are several issues that related towards the Food Industry Employees Union. The first one is whether there is a complaint of non-compliance in the collective agreement. Second, whether the action taken by the respondent in changing the working hours did not abide the Employment Act 1955. Third, whether the respondent did not provide enough rest for the employees. Lastly, whether the respondent had made wrong calculation for the rate of overtime.
Okay, so today I would like to share with you all about the consequences of dispute of this case. So basically in this case, I already choose three main issues that have been brought by the union in the industry court. And then the first issue is whether there is a complaint of non-compliance in the collective agreement by the company. These issues have been brought back because of the reason why this issue has been brought is the respondent are said to have failed to comply with the Article 16 and Article 19 of collective agreement. For your information, Article 16 is about working hours. Meanwhile, Article 19 is about overtime payment. So basically, union felt that the company did not comply with the Article 16 and Article 19. So that's why they brought these issues to the industry court. So the evidence of this first issue is the union is not informed or consulted for a change of working hours, and this matter is made without consultation with the union, whereby the union stated that they are not well informed of the changes happened because of the company did not discuss or tell them about the changes. So the decision has already made by the court, and the chairman of the court already said stated that the evidence presented by both parties clearly shows that the respondent has already informed regarding to the changes of the working hours and rest time, whereby the company or the respondent already tell about the changes to the union and employees, but the problem is the union or employees did not alert of the changes, so that's why they did not well informed of the changes happened. So we move to the next issues. The second issue is whether the action taken by the respondent in changing working hours did not abide the Employment Act 1955 and did not provide enough rest for the employee. So the reason why the union brought this issue is the respondent have changed, or the company has changed the working hours from Monday to Saturday, and Sunday is a holiday to a working day on Friday to Sunday. It means that the company changes the working hours start from Monday to Saturday, and the Sunday is a holiday day, but it changed the holiday day on Sunday changed to the Friday. It basically means that the working hours start from Saturday to Thursday, whereby Friday is a holiday day. So next is employee are not given adequate leave. So employee are not given a break on the 7th day after continuous work. So basically the union stated that the employee did not get the break or rest because they are work for every hours for every day. So the evidence of the issue is the respondent stated that the leave was given actually after the employee worked 7 days in the same week because of the changes. That's why they did not feel that they have a rest day, but actually they already get the rest day. And then if we see in the Employment Act 1955, in it does not prescribe, but they can be used as a starting point to count 7 days. This means that the count of 7 days can start from Sunday, Monday, Tuesday, Wednesday, Thursday, Friday, or Saturday. This is because it's intended to enable employers and employees to make modification regarding leave after 7 working days, depending on the suitable of the employee of the industry. So what it means is in Employment Act 1955, they already stated that they have not specific days to start the work to be a starting point to count as 7 days. So basically, in this case, the company choose Saturday to start their working days. So this is because the industry needed. And then the funding of the issue is due to difference in the leave on Friday and Sunday. It has been shown that employees are not given leave after working for 7 days. However, the court is of the opinion that the evidence submitted does not indicate that the employee did not give leave after 7 working days, although it is possible that the day off granted was valid. However, it does not indicate of non-compliance with the Employment Act or Article 16 in the collective agreement, which mean that the employers or the respondent did not breach any act in any section in the Employment Act 1955. Okay, so we move to the last issues, or the third issue is whether the respondent had made wrong calculation for the rate of overtime. So basically, in this case, respondent have not complied with the method of overtime calculation, whereby they already got they already tell by the auditor, by the external auditor to follow or to use the procedure in the CA in their payment of working hours. So the evidence in this issue is the respondent charged overtime work by not taking into account the first 8 hours as overtime hours, and only change overtime rule after the 8 hours is something that contradicts the article violates section of 60 in Employment Act 1955, whereby the company did not use the procedure of the overtime calculation to pay the overtime payment to the employee. So the result or the finding of the issue is the court said the respondent has calculated the overtime rate more than it should. It means the company pay more than actually payment. Okay, next I would like to share about the current employment law of this case. So basically in this case they have two laws that we use in it, and then the first one is the section 14 of Industrial Relations Act 1967, which collective agreement. So the definition of collective agreement is defined as a written agreement through the collective bargaining for employees or trade union with the management of the company. Collective agreement shall be in writing and signed by the both parties to the agreement by person authorized in that behalf. Basically, those agreement between two or more parties must be in black and white concept. So basically in collective agreement also have the terms and agreement. So there are 4 terms and agreement in the collective agreement, and the first one is the name of the parties. The second one is to specify the period it shall continue in force, which shall not be less than 3 years from the date of commencement of the agreement. The third one is prescribe the procedure for its modification and termination, and then the fourth one is unless there exists appropriate machinery established by the virtue of an agreement between the parties for the settlement of dispute, prescribe or procedure for the adjustment of any question that may arise as to the implementation or interpretation of the agreement, and reference of any such question to state to the court for a decision. So besides that, in collective agreement also they have things that shall be void if both parties are not give the well, if both parties did not follow well. And then the void is any term or condition of employment contained in the collective agreement which is less favorable than or in contravention of the provision of any written law applicable to workmen covered by the said collective agreement. So if we see in the case, in this case, basically they tell us about basically in this case related with the section 14 of collective agreement, because the union already stated that the respondent or the company did not comply with the collective agreement. So in this case we use this section 14 of Industrial Relations Act 1967, which is collective agreement. Okay, we move to the next law, which is section 56 of Industrial Relations Act 1967, which non-compliance with award or collective agreement. Basically, the definition of non-compliance with award or collective agreement is any complaint that any term of any award or of any collective agreement which has been taken cognizance of by the court has not been complied with may be lodged with the court in writing by any trade union or person bound by such award of agreement. So besides that, in non-compliance with award or collective agreement also have the receipt of the complaint. So this receipt of complaint is the acceptable complaint that can be accepted by the court. The first one is make an order directing any party to comply with any term of the award or collective agreement, or to cease or desist from doing any act in contravention of any term of the award or collective agreement. And then the second one is make such order as it deems fit to make proper rectification or restitution for any contravention of any term of such award or collective agreement. And then the last one is make such order as it consider desirable to vary or set aside upon special circumstances any terms of the award or collective agreement. So this section may be void if any person who failed to comply with an order of the court under section subsection 2 under subsection shall be guilty of an offence and shall on conviction be liable to a fine not exceeding 2,000 ringgit or to imprisonment for a term not exceeding 1 year, or to both, and further fine in 500 ringgit for every day during which such offence continues. So why I choose this law? Because they already stated in this case that Industrial Court Chairman used this section as a main
court found that the party respondent measured overtime costs higher than they should. This is because the respondent has taken into account an employee's working schedule of 8 hours, resulting in a more generous amount of overtime allowance payment than what can be paid as such as provided for in Article 90.3 of the collective agreement and the Employment Act 1955. The court then held that no fact easy to prove that the respondent had not agreed with the collective agreement allowed to in Article 90.3. So finally, the union parties' application by the respondent of labor agreement number court for non-compliance Article 60 and Article 90.3 of 137/2011 was refused. Recommendation is an employer should communicate clearly to the employee. A formal contract between the employer and the employee should be concluded. Unless the individual consents, the employer cannot legitimately change its provision. If a trade union is accepted, collective bargaining can result in agreement to change the contracting terms. The respondent still has finished with collective bargaining number court 137/2011 between the plaintiff and the state of the league. When the current collective bargaining accrues, the plaintiff has a mid-concession on the duration of the existing and new collective bargaining. In this form of collective bargaining, the employer owns an implicit statutory obligation to clarify explicitly the consequence of any transaction. For example, in this situation, the employer should clarify explicitly regarding changing in the working hour and the rate of overtime working. In this process also, employee and employers allow for mutual interests to be established, separate interests to be balanced against one another, and trade-off to be agreed. Will be time and attendance management system. Time and attendance management system founded by Kaizen HR is a complex functionality for time-based information management in the organization, which include time collection, time measurement, and absenteeism data collection. This system simplify all the scheduling activity for the staff, identify worker on vacation, bonus, measure, and transaction rate, for instance. It will help to increase your company performance dramatically. We need this effort remove and simplification of its schedule, but as effective as possible to adapt your timesheet to various group of the employees. This management system can save the money, time, and headaches. This also can help to ensure justice and dignity for the overtime arrangement of the workers. As the employer, they will also find certain error to estimate the overtime if they are not careful, which can lead to legal action. We can see that the respondent made a calculation error at the overtime rate. In this case, the plaintiff prosecuted them because of the fault they make. As a conclusion, the court is aware that the trade union is playing their role to protect the employee from being oppressed by the employers. The union will be support all the employee when the union set minimum wage and protection in the workplace. Union member will get the profit the most from the collective bargaining power of the syndicate to the work on their behalf with the employer. As a union delegate, this constitutional right gives you more leverage than you try to bargain as an individual. They also will get profit from joint strike control. It is a strike if a group of workers quit working either as workplace protest or as a negotiation instrument during management talks. The collective bargaining agreement is very important between employer and trade union. The agreement can improve the working and living condition of the workers. It also helps to improve the working relation by offering an institutionalist and negotiated way to resolve organization conflict through collective bargaining. This collective bargaining also will contain a peace clause and create the grievance protocol for grievance settlement during the collective bargaining era.